Okay, February 27, 2013. I'm not sure if this is a case that's still underway or if it's just they're still arguing it. But apparently this has gotten people into an uproar. Scalia condemns perpetuation of racial entitlement. And Justice Antonin Scalia suggested that continuation in Section 5 of the Voting Rights represented a perpetuation of racial entitlement, saying that lawmakers had only voted to renew the act in 2006 because there wasn't anything to be gained politically from voting against it. So, okay, the Voting Acts, he's saying, is the Voting Act's right is a racial entitlement. The right to vote is a racial entitlement. Okay. He says, even the name of it is wonderful. The Voting Rights Act. Who's going to vote against that? Yeah, well, if that name is accurate, then nobody should, because people should have the right to vote. One man, one vote, whether they're, a racial entitlement, is he saying that that racial entitlement should be preserved for only white people? Scalia said that the Voting Rights Act had effectively created black districts by law. Okay, well, I'm beginning to wonder, what is this Voting Rights Act that they are talking about? Let's look into that. Okay, to specify Section 5 of the Voting Rights Act, so let's look at the Voting Rights Act of Section 5. Okay, so search for Voting Rights Act Section 5. Court decision on Voting Rights Act could spur election changes but not turn back the clock. Come down here to Voting Rights Act Section 5 text. Maybe Wikipedia would tell me what it has. Okay, Section 5, it says, is about preclearance. Section 5 of the Act requires that the United States Department of Justice, through an administrative procedure or a three-judge panel of the United States District Court for the District of Columbia, through declaratory judgment action, pre-clear any attempt to change any voting qualification or prerequisite to voting, or standard, practice, or procedure with respect to voting in any covered jurisdiction. So if you want to change the rules that qualify people or give them a prerequisite to voting, you have many ways available to do that. An administrative procedure, or a three-judge panel, or through even a declaratory judgment. Let me see what that is. Let's see. A declaratory judgment is a form of legally binding preventive adjudication by which a party involved in an actual or possible legal matter can ask a court to conclusively rule on and affirm the rights, duties, or obligations of one or more parties in a civil dispute. A declaratory judgment is typically requested when a party is threatened with a lawsuit, but the lawsuit has not yet been filed. So this situation is when people have had their right to vote threatened, but more specifically, when a party or parties believes their rights under law or contract might conflict, their right to vote would be threatened, and that might conflict somehow with perhaps the people that are running the election system. Let's see, here's an example with cease and desist. So I'm going to try something to imagine replacing the words cease and desist with stop you from voting. Filing of a declaratory judgment lawsuit can follow one party trying to stop someone from voting. A party contemplating trying to stop someone from voting risks that the voter or a party related to the voter may file for a declaratory judgment in their own jurisdiction. This may require the person denying the voter to appear in a distant court at their own expense. So trying to prevent someone from voting presents a dilemma to the sender, or to the person trying to prevent you from voting, as it would be desirable to be able to address the issues at hand in a candid manner without the need for litigation. Right, because if you're denying people the right to vote, it's much better to do this in a candid manner without the need for litigation. Upon receiving a denial to the right to vote, the disenfranchised person may seek a tactical advantage by instituting a declaratory judgment litigation in a more favorable jurisdiction. So let's go back to Section 5 of the Voting Rights Act. Section 5 requires that any attempt to change any voting qualification or prerequisite to voting or standard practice or procedure with respect to voting must go through an administrative procedure, a 3-judge panel, or a declaratory judgment, which I was just describing. So let's come back to Scalia's argument here. Scalia says that Section 5 of the Voting Rights Act represents the perpetuation of racial entitlement. What is the entitlement here? I believe what the entitlement he's saying is this. It does not treat all jurisdictions equally. It says in any covered jurisdiction. Basically it says if you want to make changes to your voting qualifications in some districts, it's okay. If you want to make without preclearance, it's okay. But in other districts, it is not okay to change your rules to voting. So what are those covered jurisdictions? That's an important question. So with faith in Google, I say, what are the jurisdictions covered by the Section 5 of the Voting Rights Act? Okay, well, there's 9 states and parts of 7 others, including the Bronx, that get preclearance from the Justice Department or federal court to change. It requires those 9 states and the Bronx and several others to get preclearance from the Justice Department or federal court to change their election laws. Why do those 9 states and parts of the 7 others get chosen for preclearance like this? Probably because they've abused the voting rights in the past. The law quickly led to blacks registering in proportion to their population, and over time many more elected black officials. Oh no. In 1972, Alabama, 80.7% of whites were registered to vote compared to only 57.1% of blacks. By 2004, 73.8% of whites were registered compared to 72.9% of blacks. It's getting up there towards equality right there. By 2004 in Georgia, Mississippi, and North Carolina, a larger proportion of black residents were registered than white voters. In the sense the Voting Rights Act is one of the most the Voting Rights Act is one of the most successful laws in American history. The question in Shelby County versus Holder is whether such federal supervision over some parts of the country is still necessary amid so much racial progress. Congress originally set Section 5 to expire after 5 years. It was reauthorized in 1970 after 5 years, and has since become politically untouchable, and was reauthorized in 2006 for 25 more. So the thing is, there's these 9 states and parts of 7 others that are essentially being treated unfairly because they currently have a situation where they actually have to pre-clear any election changes, while all the other states in the nation and all of the other places in the nation do not have to pre-clear changes to their election rules. Now, I think there's two applicable solutions to this problem. There's one, we could say, Well, everybody needs to pre-clear their election rules, pre-clear changes to their election rules, and then you don't have a racial entitlement. Or you could say, let's get rid of these racial entitlements. We don't want these states. They've been giving black people the right to vote for too long. Let's get rid of those racial entitlements so that we don't have to pre-clear our changes to our elections. That's another way to do it. So we got to ask, who should be able to decide when the discrimination problems that the Voting Rights Act was meant to address had ended? And that's a good question. When do you decide that it is okay to people to make arbitrary changes to their voting standards, practices, procedures? When do you decide it's okay for them to deny or abridge the rights of citizens to the United States to vote on account of race or color? When do you decide that it's okay for people to start discriminatory practices without preclearance? So these enforcement provisions applied to states and political subdivisions, mostly in the South, that used a device to limit voting in which less than 50% of the population was registered to vote in 1964. Okay, most of those places now have a considerably higher percent of population of these minorities of voting. And people have argued that it places unwarranted bureaucratic demands on southern states that have long since abandoned the discriminatory practices the act was meant to eradicate. Well, my personal opinion would be that actually maybe it is time to try to create a more fair rule, one that doesn't just apply to 9 states and parts of 7 others, but one that requires fairness and to all states, not just the ones that have demonstrated discriminatory practices in the past. But is there any time right now to put together such a law? Is the 113th Congress of the United States actually capable of putting together good law with its majority Democrat Senate and its majority Republican House of Representatives, who a large number of whom are really in power because of gerrymandering? I think Scalia has somewhat of a point that we don't want to fix it so that the Republicans in these states, or the people in these in the gerrymandered states, get to change their voting rights laws completely arbitrarily, while well, let me ask this question: were the most gerrymandered states covered by Section 5 of the Voting Rights Act? Of course, that's not going to pop up easily in the Google, but here's Pennsylvania, with Republican-held seats in red and Democratic seats in blue. Shows the president's party with 5 of Pennsylvania's 18 House seats. 1 here, 1 here, and 3 down here, I think. Uncompetitive Democrats have been packed into 3 uncompetitive seats around Philadelphia, that's here, an uncompetitive seat in Lehigh Valley, and a safe seat in Pittsburgh. The state's suburbs, exurbs, and rural areas have been rigged to be just outside the range where Democrats might win them. Here's Ohio, where Democrats have been packed into 4 deep blue districts. So Republicans were able to control the process in Ohio and Pennsylvania and North Carolina, Michigan, and gave themselves similar maps. And Democrats played the same game in Illinois and Maryland, squeezing out suburban Republicans by packing just enough of Cook County and Montgomery County, respectively, into their districts. So my question is, this process of gerrymandering, shouldn't be done anywhere, right? But my question is, are these states is the gerrymandering, the ability for some states to gerrymander, are they, would the rights of these people to get their votes counted be included in the Voting Rights Act Section 5 or not? Here's a website at Princeton that says a minimum condition for a representative outcome is that within a congressional delegation, the party receiving more votes should end up with more congressional seats. In the November election, the following groups failed to meet this minimum representative. Arizona has 55.4% Republican votes, but it ended up with 5 Democratic seats. Michigan had 52.7% Democrat, but the Republicans got 9. Huge discrepancy there. Another small Democratic lead here, huge Republican majority there. Small Democratic lead here, huge Republican majority there. Small Democratic lead there, huge, well, that's just a normal Democratic, or a small Republican lead. But you can see this Michigan, North Carolina, Pennsylvania, there's a huge discrepancy between the actual number of seats versus the popular vote. Here are the jurisdictions requiring preclearance. Here's Arizona. Arizona is the one where the Democratic vote, where actually the number, where this was kind of reversed, where there were more Republican seats, or there were more Democratic seats than Republicans, even though the Republican vote was higher. So these are the states. Wait, didn't I say 9? 1, 2, 3, 4, 5, 6, 7, 8, 9. I missed one. Okay, these are the states with protected voting rights. Alabama, Alaska, Arizona, Georgia, Louisiana, Mississippi, South Carolina, Texas, and Virginia. These states, Michigan does not have protected voting rights. North Carolina does not have protected voting rights. Pennsylvania does not have protected voting rights. Wisconsin does not have protected voting rights. The interesting thing is Arizona does have the protected voting rights, and you'll see that it was it does appear that the gerrymandering went in the other direction with Arizona. But it should also be noted that this is fairly minor. This is within the realm of what ought to happen. 5-4 versus 45-54. These three, Michigan, North Carolina, and Pennsylvania, are ridiculous. You have a majority of people voting one way, and the vast majority of the Republican seats go the other way. So Antonin Scalia says this is the perpetuation of racial entitlement, and I kind of feel like maybe this Voting Rights Act should be extended throughout the United States. We should all be entitled to have our voting rights. We should all be entitled to be informed about what our voting rules are, and we should be armed with the information of how our system works, how our voting system works, and when people try to stop anyone from voting, whether of any race, they should be required to pre-clear any attempt to change any voting qualification or prerequisite to voting, standard practice, procedure with respect to voting in every jurisdiction, not just in Alabama, Alaska, Georgia, Louisiana, Mississippi, South Carolina, Texas, and Virginia. This shouldn't be we shouldn't get rid of the Voting Rights Act. We should extend it throughout the country.